Estate planning applies to all adults, and just like good dental hygiene, it is important to review and refresh your estate planning on a regular basis. In its simplest form, we recommend that all of our clients obtain a four-part will package. The will package should include a last will and testament, also known as a property will. This is the document that directs the distribution of your assets. However, there's an important exception. You can and should use beneficiary designations whenever possible. This is the simplest and easiest way for the executor of your estate to distribute assets. Beneficiary designations can apply to retirement accounts and supersede your will. So a 401k, 403b, and IRAs can pass outside of the probate process. You can name a primary or multiple primary beneficiaries and assign the same or varying percentages to each. You can also name contingent beneficiaries, but keep in mind that contingent beneficiaries only apply if the primary beneficiary predeceases you. Otherwise, the contingent beneficiary has no effect. Bank accounts use a POD or payable on death designation. This works similarly to a beneficiary designation and supersedes your will. Again, you can name both primary and contingent PODs. Non-retirement investment accounts utilize a TOD or transfer on death designation. Again, this is similar to a beneficiary designation and passes outside of the probate process. So as you can see, you can transfer the bulk of your assets through these three designations. However, you should still have a last will to direct the distribution of assets not covered under designations. Real estate is usually the biggest asset that is not covered under a designation of some type. While a last will provides direction to an executor to distribute assets after death, a financial power of attorney has the ability to direct the use of assets while you're still alive. This is very important if you become incapacitated. Keep in mind that all of your retirement assets by definition are individual accounts. You as the owner are the only person that can provide direction on the distribution of those assets unless a financial power of attorney is in effect. Financial power of attorneys can be durable, meaning they are in effect until revoked, which can be used as a convenient tool for signing documents on behalf of a spouse. Financial power of attorney can also be a leaping financial power of attorney. In the case of a leaping financial power of attorney, a doctor certifies that you're incapacitated. So this requires an extra step, but either method avoids the need to obtain an emergency power of attorney. Healthcare powers of attorney are similar to financial powers of attorney, except they are used in a healthcare setting. It provides a designated person the ability to make medical decisions on your behalf if you're unable to do so. So choose the person wisely. The last of our four-part will package is a living will. A living will outlines your preferences for end-of-life medical treatment if you're incapacitated and unable to communicate your wishes. It should specify the extent of medical treatment that you desire, for example, the use of ventilators and CPR, providing nutrition and hydration, and pain management. So keep in mind it is legally binding. Be thoughtful about how you answer the questions. You can obtain a four-part will package via an online document service or via an attorney. We do recommend using an estate planning attorney wherever possible. An estate planning attorney specializes in the distribution of assets when you die and can help address what happens if you become incapacitated. They have the ability to customize the documents to your particular situation. While technically you may not have to notarize a will, it is definitely best practice to do so. So please have all of your estate planning documents notarized. If you have any more questions, feel free to reach out to us and check out our video on revocable trust. Thank you.